Hi, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about veterans and injuries. Cases that should have gone to the Supreme Court of Canada, but didn't. Daniel Scott applied to the court for an order declaring the Members and Veterans Compensation Act to be unconstitutional. And the reason he sought that order was that he said that its caps on how much veterans can receive for injuries they receive in the line of duty was inconsistent with a common law duty that the Crown owed to individuals who had performed military service. Relying on case law from the Indigenous law context, Mr. Scott argued that there was an honor of the Crown recognized at common law that meant that the government had to do more when it came to protecting military members and when it came to compensating them for their injuries. His case was dismissed, and the Supreme Court of Canada denied leave to appeal. But this case obviously raises issues of national importance. In fact, issues around the compensation that veterans receive for their injuries, which can often be lasting serious psychological harm or physical injuries that are irreparable, like the amputation of limbs. That's something that affects huge numbers of families across this country. And the issue of compensation for these claims has been something that numerous governments have promised to do something about, but have never done anything about. This was an opportunity for the Supreme Court of Canada to recognize an obligation that the government owes to the people who sacrifice and make huge sacrifices in service of their country. And whatever your feelings are about certain military actions undertaken by military servicemen in this country, it's certainly important to recognize that those people that think that they are doing what is right and who follow through on a mission that the government sends them to without asking questions in service of what the government says is right should be treated fairly by the government, and limiting their ability to claim by creating legislation that then ousts any duty that the Crown owes to them seems to be significantly unfair and out of step with the respect that we're supposed to have for members of the military. The Supreme Court of Canada could have recognized and clarified whether there is an obligation at common law and the extent of that obligation. And unfortunately, by denying leave in this case, they left military members and the families of military members who have suffered as a result of injuries, whether physical or psychological, a little bit in the lurch. Hopefully another day, the Supreme Court of Canada will have the opportunity to revisit this issue and determine whether the government owes more than just what they decided was necessary in legislation to people who have sacrificed in serving the country. You're watching Cases that should have gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull for putting together these videos. Like, subscribe, share with your friends, and tune in next week for another episode.